On the record in the matter of the state of Michigan versus Gino Garcia 24-00948. Appearance, please.
Morning, Arraignment, Nagel for the people. Get with Goodrich as the defense attorney.
Appearance.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Garcia, who is standing to my left. May I approach with an advice of rights form and a plea sheet?
Ensuing parties are waiving exam.
Yes,
Correct, counsel.
that is correct, Your Honor.
There's a plea offer here for you to plead guilty to the amended count 1 of use of a controlled substance under MCL 333.74042B. That's a misdemeanor. Maximum penalty is 1 year and/or $1,000 in fines. Is that correct, sir? Sir, accept that offer? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Put your hand down. Would you read these rights? You understand all the rights here? You're willing to give these rights up today to plead guilty to the amended charge? That means you're gonna give up your right to be presumed innocent. So you're innocent until proven guilty. You know that? You wanna give, why are you looking at him? Like he didn't tell you that.
He did.
Okay, so you want to give up your right of the presumption of innocence? Okay, you're also giving up the right to proceed to jury trial where you will require the prosecution to prove each element of the charge that they're bringing against you beyond a reasonable doubt. Your right to remain silent at any trial and not have that silence be used against you. Your right to confront and question in court any of the witnesses that they call to testify against you. Your right to subpoena witnesses that will testify on your behalf. And your right to waive that silence and testify at your trial if you like. You understand those rights that you give up?
Yes.
Is there anyone that's threatening you to get you to give these rights up? And any promises been extended to you, not stated here on the record, in order to get you to give up your rights and plead guilty? You're currently on probation? Are you on parole?
No.
You have any other matters pending in court?
I drive.
Some driving license suspended stuff? Okay, I understand that by pleading guilty, it could result in a conviction that you may need to report to your current or a future employer. You may need to report it to a current or future employer if you plead guilty.
Yes.
Okay. You also understand that it could have impact on where you can travel or get immigration status.
Yes.
As to the amended charge of use of a controlled substance, how do you plead?
Good.
Factual basis.
Your Honor. Mr. Garcia, on or about September 12th of 2023, were you at a location on Donald Street near Fenton Street?
Right with that.
Okay, were you in the city of Lansing at that time though?
Yes.
Okay, County of Bingham, State of Michigan? And did you come into contact with an officer from the Lansing Police Department? And at that time, did you, were you in possession of a substance that had cocaine in it? And you were aware that that was cocaine? And you didn't have any type of prescription or any type of legal authority to possess that cocaine? Your Honor, I believe he has provided a factual basis to the underlying charge in this matter.
Questions from the prosecution?
No, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. If this matter is scheduled for sentencing, it's going to be March 13th at 9 o'clock in the morning. Prior to sentencing, you need to meet with probation. So when you leave here, you'll go down one floor so you can check it with our probation department. They'll get you set up for a pre-sentence interview. You also need to undergo a substance abuse assessment prior to that interview. You understand that? Do you have any questions about what you're gonna do from here until your sentencing date? I'm sorry,
What am I exactly doing from here?
what I just said to you.
I was just going out and report.
You're gonna go report, they're gonna give you a questionnaire to complete, you're gonna get information as to where you can do a substance abuse assessment, which is required. And then they will get a release from you to get a copy of that assessment. And then they can move forward with completing a recommendation after having an interview with you. So you're also going to get an appointment to return to them for an interview after you go down today to meet with them. Do you understand that? Okay, do you have any questions about that? Okay, and you can report for your sentencing via Zoom. Any additional matters for the record?
No, Your Honor. Thank you. No, Your Honor. Thank you.
You're all set for today. Have a seat until we get you downstairs.
Your Honor, if the court prefers, Mcdermit is going to be a plea as well.
What's going on with Lake?
Leighton, we're going to be running that exam.
It's on the record in the matter of the state of Michigan versus Lamont Mcdermit, 24-02934. Ms. Mcdermit downstairs though?
Yeah, he's in custody, Your Honor.
Okay, well, we bring him up.
I apologize, I guess we're not ready to go on that.
On the record in the matter of the state of Michigan versus Chase Scruggs, 24-03567. You can have Mcdermit brought up, please. Counsel appearance.
This is an arraignment.
Okay, I have two files here. So I have 25-00045. Yes.
Matt Nagel for the people.
Hey, good morning, Your Honor. Dustin Coons for Chase Scruggs, who's here to my right.
Okay, let's see, what is this? I have a file here that you can be arraigned on, then there's a bond violation. It's a misdemeanor complaint that alleges, this is in file number 25-00045. It alleges that on or about October 2nd, 2024 at 6264 Cooper Road, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the act of computers using to commit a crime, maximum imprisonment of 1 year or less. It alleges that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit under MCL 750.145E and that this was contrary to 752.796 and MCL 792.7973A. This is a misdemeanor. Maximum penalty is 1 year and or $5,000 in fines. It also states that reimbursement to the government for expenses incurred in relation to the violation in the manner indicated in MCL 769.1F may be ordered, and a consecutive sentence may be imposed for the underlying conviction. There's a count 2 of intentional dissemination of sexually explicit visual material. The allegations is that on or about October 2nd, 2024 at 6264 Council Road, Lansing, Michigan, that you did with the intent to threaten, coerce, or intimidate, disseminate any sexually explicit visual material of Olivia Winter Shook, another person who was not less than 18 years of age and was identifiable from the sexually explicit visual material itself or information displayed in connection with sexually explicit visual materials, and the sexually explicit visual materials was obtained under circumstances in which a reasonable person would know or understand that the sexually visual material was to remain private, and knew or reasonably should have known that the person did not consent to this dissemination of the sexually explicit visual material, and that this was contrary to MCL 750.145F. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. Understand the charges there and the maximum penalty that's read. You have the right in this matter to proceed to trial. You have the right to be represented by an attorney. If you can't afford to hire or retain an attorney to represent you, you can apply to have the public defender's office represent you at the expense of the public. Do you understand that? Okay. Let's see. I have in 24-03567. A bond violation. The allegations are that on or about January 21st, at approximately 1500 hours, officers were dispatched to make phone contact with the protected party in the underlying case regarding her ex-boyfriend identified as Chase Scruggs for violating a personal protective order she has against him. Let's see. Officers said through their investigation, they were advised that while Scruggs was out on bond, you can see on multiple videos from her surveillance cameras from driving his vehicle by her house on multiple occasions in the last few days. She knows his vehicle because he drives a white Mercedes with a black gas cap. She provided multiple videos of surveillance to officers about her residence. She said there indicates feeling unsafe at her home due to this issue. She advised that she believed Scruggs created a fake Facebook account and added her as a friend. She thinks the account belongs to Scruggs because he's the only mutual friend on the account, and the name on the account is an alias he used to go by. So these allegations would be a violation of your bond condition. Your bond can be revoked pending the underlying prosecution of the charge of home invasion first and domestic violence. You also could be sentenced to a contempt of court if found to be in violation of your bond conditions. Do you understand that? Okay. How does your client want to plead for the bond condition?
Not guilty, Your Honor.
Or will enter a plea of not guilty on your behalf. I think you're scheduled to have a exam on the 21st. We'll set this for a hearing on the PA 53 on February 21st at 8:30. As to the new matter that you were arraigned on, you have the right to trial, you have the right to jury trial, and you have the right to be presumed innocent until proven guilty. If you're found to be, if you remain silent, this matter will proceed to a jury trial. At the time of trial, you have the right to see, hear, or question any other witnesses that the prosecution intends to call to testify against you. You can subpoena witnesses that will testify on your behalf. Or maintain your silence or waive it and testify at your trial if you'd like. Do you understand those rights? How's your client plead for the computer's intent to disseminate charge?
Not guilty, Your Honor.
The court will enter a plea of not guilty. Do you intend to retain counsel for this matter, or are you going to seek public defender representation?
I'm sorry, sir. I thought we filed our agreements. So we'll make sure it gets in the file.
It's in the system. Okay, we'll note here that you are declining an appointed counsel that you've retained from law firm. Counsel, you can address the bond issue.
Thank you, Your Honor. At this stage, I'm asking the court to continue the current bond conditions, but on the felony case, the pre-existing ones, and on the misdemeanor case, I'm asking for a personal cognizance bond. I think if the court determines after further hearing that there need to be additional conditions, the felony file would be the appropriate vehicle for that. That said, well, I don't want to litigate the underlying allegations of the PA 53 violation. Following my client's being arraigned on these felony charges, one of the things we talked about was having his location services on so we can make sure we know where he's at and when he's at that place. He's done that, and I think allegations for bond violation proved to be false. So I could be wrong about that, of course. And
There's
that's,
video supposedly.
I haven't seen it, Your Honor. I understand that.
Officer said they uploaded it in evidence.com, so you should seek to get a copy of that.
Yes.
It's not been provided yet.
Yes. But at this time, until the court hears actual evidence on the record, I'm asking for a continuation of conditions. If the court disagrees with me, rather than revoking Chase's bond, I'd ask for a GPS tether.
The concern that I have is that the victims in both matters is the protected party. The allegations, quite disgusting, a home invasion, first degree, where the allegations was that your client made entry into this person that he used to be in a dating relationship with into their home without permission, which is jarring. That there's allegations of assaultive action, that he assaulted her. Then there's now allegations that some photos, videos, or some other visual information that he allegedly had possession of that he should have known was private, that to be vindictive, he disseminated it. And then now I have an allegation that just this week, there's video evidence of him driving past our house, which is stalking. Remanding him into the custody of the Ingham County Jail until a hearing.
Internal, sir.
I'm going to remind you that the no contact ordering continues while you're in jail. So it would not be advantageous to try or attempt to make phone calls to the protected party from the jail. It's recorded. The prosecutor's office in Ingham County listens to the calls. I'm also going to advise you that it's not advantageous to try to have a family member call on your behalf. The prosecutor's office listens to those calls. It's not advantageous for you to try to use another inmate's number. You hear where I'm going with this?
Yeah.
Thank you. We're adjourned for today on this matter. On in the others, a $500 personal recognizance.
I'm sorry, personal recognizance.
Correct.
Thank you.
On the record in the matter of the state of Michigan versus Lamont McDermott, 24-02934, 24-02156, 24-01757. Counsel appearance.
Good morning, Your Honor. Matt Nagel for the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. McDermott. He is present to my right at council table.
Okay, today was the date that was scheduled for a preliminary examination of sentence, another preliminary examination. Counsel, would you say we were doing on this?
It's my understanding that the defendant is going to be taking advantage of the plea offer today, Your Honor. That is to plead guilty to an amended count 2 on file 24-02934FY. That'd be amended count 2 DD first. People would dismiss the count 1. In exchange for that plea, the people will dismiss file 24-01757FY. And in exchange, the defendant is also planning on pleading guilty to what I understand is a pending PA 53 violation.
Sheet,
Yes, Your Honor.
that's accurate. I
Yes,
think you said no
except-
contest, is that what it is?
Correct. It'll be a no contest plea to the EV charge. It will be a guilty plea to the bond violation. And I do have an assigned advice of rights and the pertinent portion of the police report for the court to review if I may approach.
That is correct, Your Honor. I
What's the
misspoke on
purpose of the no
guilty plea.
contest plea? Thank you.
Sorry,
What's the purpose of a no contest plea?
potential for civil liability. Your Honor.
That's how you want to proceed, sir? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can put your hand down. Okay, so you want to plead no contest to amended count 2 domestic violence 1. And that's in file number 24-02934. And you will count 1. I'm saying people will dismiss count 1. And in file number 24-01757, you'll plead guilty to the police officer assault. Is that correct?
No, Your Honor, it is. In the file that he is pleading no contest to the domestic violence, there's a pending PA 53 violation as it relates to jail calls. He would be admitting to that bond violation as well as pleading no contest to the DV first in that file. The balance of the charges in that file would be dismissed. His pending R&O case would be dismissed.
Okay, is that correct, counsel?
That is correct, Your Honor.
Okay, people would dismiss the file 24-01757. The agreement. Then he'll plead guilty to a bond violation. And the file that he's pleading guilty to. Let me see here. What's going on in 4-2156? It's not listed on here at all.
That's the sentencing, Your Honor.
Okay, sounds good. Did I refer him to probation at all?
Not on that file, I believe, Your Honor. That is Ms. Sutter's file. I believe the court was willing to do immediate sentencing the last time, the time he did the plea taking. I believe it was adjourned out.
Got it.
So to give the victim an opportunity to appear if they wish to do so.
Sounds good. Okay. Sir, do you understand that you have the right in these matters to proceed to a trial with the presumption that you're innocent until proven guilty? You have the right to require the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial and not have silence be used against you. You have the right to have witnesses subpoenaed to your trial to testify on your behalf. You can waive your silence and testify at your trial if you'd like. And you have the right to see, hear, or question any witness that the prosecution intends to call to testify against you. You understand all those rights that you'd have to give up today? Is there anyone threatening you to plead no contest today?
No.
Any promises being made to you if you plead no contest? Are you currently on probation or on parole? You understand that by pleading no contest, a guilty plea could be entered that you may need to report to a current or future employer. It also could have impact on where you can travel or get immigration status. Do you understand that? As to the amended charge of domestic violence, one under, I'm in file 24-02934, how do you plead? No contest? Okay. Let's see, I have a police report. Case number 245-1909381. By Officer Colleen Riley. In that on or about September 26, 2024, at approximately 12:33, officers were dispatched to the area of 4554 Seaway Drive on a report of an unknown trouble. The caller was using 911 text and provided only the address and nothing else. The caller used, let me see. The victim and the accused have been in a dating relationship for approximately 9 years. They share no children in common. Victim identified as a Lauren Diane Perrett advised that she had been arguing with Mr. McDermott all morning. So she collected her belongings and headed out the door to leave. When she did so, Mr. McDermott stepped in front of her, pushed her backwards and told her she wasn't leaving. Lauren does not recall exactly where she was pushed, somewhere in the upper body region with both Lamont's hands. That's the extent of the factual basis.
It is, Your Honor, and I would stipulate that address on Seaway Drive is in Lansing, Michigan, Gino County.
Exactly is the potential for civil liability there.
Well, Your Honor, obviously the allegations against Mr. McDermott were far more serious. They're being dismissed. It is possible that one, she could seek some type of civil remedy against them, depending based on those more serious allegations. Also,
Let me stop you there, but isn't that happening in every assaultive case then? Because if that's the case, we can just do no contest for everybody. There has to be a legitimate basis whereby I'm accepting a no contest plea. Like there's actual risk of civil liability, not that he just doesn't want to say, I plead guilty. So I'm trying to understand, based on this, what is the actual risk of civil liability?
I guess to the extent of whether or not how likely it is, I don't know. All I know is it is a possibility and a legal possibility, and any admissions that he makes in a guilty plea could potentially be used against him should she decide to do that.
That legal possibility is inherent in every domestic assault then, and so that would not warrant justification for me accepting a no contest plea. Did she get hospitalized? Was there allegations of an injury? Because I have taken or see, and you, as have you and the prosecutor, far more serious domestic accusations that could actually lead to potential liability. I'm not seeing an ounce of potential liability here.
I understand, Your Honor. I guess I would just rely on my original comment.
I'm not in a position to, I don't find the reason for a no contest plea appropriate.
That is the case, may I have a moment?
Absolutely.
Your Honor, then if the court wishes, Mr. Mcdermit would like the opportunity to change his plea to a guilty plea and lay a factual basis for the charges.
Okay, so as to the amended count 2 of domestic violence, you want to enter a plea of guilt? And you understand the rights still apply, that you're innocent until proven guilty?
Yes, I do.
Okay. Well, how the factual basis is much different, but we want threatening you to enter a guilty plea?
No.
Any promises being made if you change your plea to guilty?
No.
I think the factual basis has already been sufficiently laid as to domestic violence. Any additional factual basis?
Satisfied, Your
Other court will accept your plea if I am pleading free voluntarily and intelligently made. There was a PA 53. I don't even see where he was actually arraigned.
He was, Your Honor. It was shortly after the case began. Mr. Mcdermit has had his matters adjourned, I think initially because of court's unavailability and some other reasons, but I believe I was here and he was arraigned on those allegations
Jail
of the PA
calls with the
53.
allegations.
Yes.
Let's see. This was the date that was set for an exam. Did we have a victim here at all?
Not for the domestic violence case here.
Okay, and you had one for the sentence, the one that was scheduled for sentencing?
Not for the one scheduled for sentencing. Nobody showed up for that.
Okay, well, my concern is that I think he's been in custody on this for
I
3
think
months
on this,
max.
on this file, Your Honor, my calculation would put him at, I think, 119 days as of today on the file he just pled to. I think he has a little less on the A and B file that he was going to be sentenced on simply because I think he had a PR bond for a while. But on the file that he just submitted to, my calculations show him at 119 days credit on a 93-day misdemeanor at this point.
And my understanding is that the victims never appeared on this? Or-
That's my, yes, Your Honor.
Okay, well, I don't think it's meaningful to set this out for a sentence, and I think that we satisfied essentially a crime victim, right? Because she failed to appear today.
I agree, Your Honor.
the objection to immediate sentencing?
None, no, Your Honor.
I'm not opposed to that, Your Honor. Thank you.
Okay, you've already served the time, so I'll credit you time served. You're all set.
Your Honor, does that apply to the AED file as well?
For both, yeah.
Okay, thank you, Judge.
Thank you.
Oh, sorry. I remember, I'm sorry. Your Honor, if the court would like, we can do fashion. It sounds like unfortunately, Clinton County has him, so he's, I don't know, I'm sure we get a writ, but apparently Clinton County undermined that.
For who?
J1 Bastion.
Bastion, oh, I do see Clinton County.
Probation violation.
We need to, is that the issue?
I think it was being held here, but at Clinton County. Rated or something.
So they didn't bring him today?
Oh, so he's not here today?
He's not going.
Supposed to be.
Yeah, it's,
I went downstairs and they said they didn't bring him from the county, and apparently he's in Clinton County.
Probably the.
Ready to go on Layton when the court is, I don't know if I saw, I think I saw the AG up there, but
I did see the AG, but what happened? Did I get booted?
no, he's on. Oh, you guys.
Still saying it in there.
It says you're still in there.
What happened? Oh, we are there. Lost you. You can hear us? Okay, let's see. On the record, in the matters of the state of Michigan versus Darius Moore, and Sienna Stevens. That's file numbers 24-032858687. Appearances, please.
Morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people, P69006.
Assistant Public Defender John Lee, appearing on behalf of Darius Moore. I am substituting for Luke.
We need the defendants to start their videos. Okay, let's see here. Only one defendant is represented by your office. That's Darius Moore. Darian Moore was denied a request of an attorney, as was Sienna Stevens. I think we adjourned this to see if they can get or hire counsel. I need an update on that. Let's start with Darian Moore. Please unmute and tell me what's going on with your request to confine an attorney.
Yes, first of all, good morning, Your Honor. I
Good morning.
did. I have been searching for an attorney the past 2 weeks. I have been talking to some, working on some, but I do not have one at this time.
When do you anticipate that you'll have an attorney?
Honestly, I can't give you a date. It's still being worked on. I have been talking to some. I have been trying to get one, but I haven't. I don't have
What
one.
attorneys have you spoken to?
Uh, I will- I've been talking with my cousin, who works for one, who works within the whole circle, and I've talked to one.
What attorney did you talk to?
I can't remember his name at the time. At this time, Your Honor.
Because you didn't talk to any attorneys, that's why.
I
Ms. Stevens, unmute. Ms. Stevens, I need you to unmute your device.
I kept clicking my picture.
Okay, no worries. Ma'am, what efforts have you made to hire an attorney?
I had talked to someone, but she has been like in and out of office.
Who's the someone?
I forgot her name. She said she was working with someone in her office to
You
get
forgot
somebody.
her name, but she was working with someone in her office. When did you talk to her?
Yeah, last week. I haven't been talking to her like a
How
lot
do you, how do you know she's in and out the office?
because I had talked to her like a few days ago.
Oh, go into your phone and tell me what the number was of the person you talked to.
It's in my emails. Her name is Jasmine Valentine.
Jasmine who?
Valentine.
Okay, so you attempted to make contact with Jasmine Valentine, I am familiar with her name, to represent you?
Yes.
Okay, and do you believe that you're going to further engage with her to see if you can retain her, or are you still, or have you resolved that she may not be able to retain you and you need, or you may not be able to retain her and you may need someone else? Because it's not very difficult in a criminal matter to find out if you can afford them or not and move on. So this whole concept of I've been talking to my cousin who works in that circle, all that is fake news, okay? If you want to hire an attorney, you reach out to them, you tell them what the charges are, and they will give you either a free consultation or get some information from you, and they give you a quote. You're not gonna tie up my docket, you're not gonna tie up this prosecution while you do not do your due diligence to see if you can hire an attorney. Mr. Moore, you are facing up to 10 years in prison. These are serious charges. To sit here and tell me that you're just talking to a cousin that's in that circle is irresponsible of you. Your lackadaisical nature of handling this could land you in prison.
I understand, Your Honor, and I apologize. I have been talking also to Miss Valentine about getting a lawyer because I talked to multiple. I've tried to get quotes and I couldn't afford one. I have been talking to Miss Valentine as well, Your Honor. I'm not trying to be lackadaisical. I apologize.
And so you both believe you're gonna hire the same attorney?
Yes, we're both trying to. That's the conversation that we have been talking to. They're trying to figure that out.
Okay, because you would, of course, need to waive any conflict if you want to do that. Do you understand that?
Yes, ma'am. Yes, Your Honor.
Okay, Mr. Hayes, I'm going to reset this for a next available date so that they can give me some clearer understanding as to whether or not they're going to be hiring Ms. Valentine, and maybe if they are able to waive their conflict, it can save them a little money in their defense. I don't know. Any objection to that?
No, Your Honor, I understand. I think I mentioned this last time, but I'm still willing to make myself available to both unrepresented defendants if they are interested in having a conversation with me in order to save some money as well.
February 6th. February sixth at 8:30.
Thank you, Your Honor.
No problem. Do either of you have any questions for the court today?
No, I do not, Your Honor.
Stevens, do you have any questions?
No, Your Honor.
Mr. Darius Moore, do you have any questions?
No, I'm all right.
Set PCC for Dennis. Well, to February sixth at 8:30. Any additional matters for the record?
Not from the people, Your Honor. Thank you.
Looking for the detention.
Thank you. You're all set.
I actually do have a question.
Yeah.
This I think you said February 6th is I can't think of the term. The preliminary
27th.
defense, is that still the same date as of for right now? I think it's like the
Your
end of February.
February 27th date is still the date for your exam.
Okay, that's all I needed. Thank you, Your Honor.
No problem. And to be quite honest, Darius Moore, I don't even know if he needs to come for another PCC. I don't see why he needs it. He has an attorney. So Mr. Darius Moore does not need to appear unless you or Mr. Goodrich thinks it's meaningful.
Very well, thank you.
Thank you. Any additional matters for the record?
Thank you, Your Honor.
Thank you. You're all set.
Your Honor, you said the next one is February 6th is it the 9th or is it the same time or 8 o'clock?
8:30.
Okay, and for the preliminary, would that be Zoom as well? Or that's in person?
Your probable cause conference, which is the February 6th date, you can appear via Zoom. Preliminary examinations must be held in person. And then when we are here on February 6th, if you've retained counsel, and by then you hopefully should have, Ms. Valentine will advise if those dates work for her.
Okay, thank you, Your Honor.
You're welcome. You're all set. Thank you.
Okay, thank you.
the record in the matter of the state of Michigan versus Zachary Leon 24-02961. Appearance for the record.
Good morning, Your Honor. Matt Nagel to the people.
Your Honor, Assistant Public Defender John Lee appearing on behalf of Zachary Leon. I am substituting for Stephen Mills today.
Today was the date that was scheduled for preliminary examination. My understanding is that we're ready to proceed on this.
That's correct, Your Honor.
Any matters we need to address?
Your Honor, I have 3 exhibits. However, I don't believe there's any stipulations at this point. So, other than that, Your Honor, I think the people are prepared.
Anything from you?
It sounds like we are going to stipulate to count 2 is possession by a prohibited person based on a prior conviction of a felony, Your Honor. Along with that would be the felony firearm attached to count 2, so that would encompass count 3. Sounds like for the purposes of the examination, we are going to stipulate to the prior conviction and therefore to counts 2 and 3.
Stipulate to the prior conviction that support counts 2 and 3?
Yes, sir.
Yes, sir.
Yes.
Stick to prior conviction, okay.
So today's examination would just be based on count 1. the specific.
Well, okay, there looks like there's a stipulation as to the prior conviction. We have a weapons possession by prohibited person and a weapons felony firearm. So
Well,
it's still,
yes,
he's not stipulating to those charges.
I misspoke. That's correct.
Okay.
Yes, so it would be all 3 counts. You're right. I'm
Sounds
sorry.
good. Okay, any other matters?
Nothing further.
Please proceed.
Thank you, Your Honor. The people
You
will
can have a
call
seat.
Officer Harold.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Do.
You can have a seat. State your first and last name and spell both.
Carter Harold, CarterHearld.
Counsel.
Thank you, Your Honor. Good morning, Officer Harold. Can you tell the court with whom you are currently employed? Lansing Police Department. What do you do for, and how long have you been employed with Lansing Police Department?
Since May 6th of 2024.
So. Okay, and approximately, and what is your, what are your current duties with the Lansing Police Department?
I'm a police officer who works on a road patrol.
Is part of those responsibilities to conduct traffic stops?
Yes.
Were you working in this capacity on October 1st of 2024?
Yes.
And during your shift, approximately early in early morning hours, do you recall making a traffic stop in the vicinity of 600 South Sycamore Street?
I did.
Was that city of Lansing, County of Bingham?
Yes.
Can you repeat that address?
600 South Sycamore Street. Can you tell the court about that traffic stop, please?
Conducted the traffic stop for expired registration tab. Once the vehicle pulled over, made contact with the driver. Had his license, he was visibly nervous, his hands were shaking.
Was the driver the only person in the vehicle?
No, it was a passenger.
There was it. Okay, so there was a passenger, just 2 people in the vehicle?
Yes.
And during your traffic stop, were you able to identify both the driver and the passenger?
Yes.
How were you able to identify the driver and the passenger?
The driver handed me his license after I asked for it. The passenger, I asked for his ID and he gave it to me.
Okay, and what did you do? Did you do anything with the ID to confirm the identity of the passenger?
I looked at it, it was the same, the picture was the same as the passenger. I ran it through our Lean SOS system.
Okay, and when you ran it through the Lean SOS, what did you discover?
The passenger had a warrant.
Okay, with that information, what did you do?
I arrested the passenger.
Do you see that passenger report today?
Yes,
Can you point to him and identify an article?
he's wearing the black shirt.
Your Honor, will the record reflect ID?
Any objection to identification?
No objection.
Identification is noted.
So did you inform the passenger then about the warrant?
Yeah.
And after informing him, were you able to take him into custody?
Yes.
And can you tell the court what happened when you took him into custody?
I placed him in the backseat of the vehicle.
Did you search him?
Yes, I searched him.
Did he have anything on him that was of evidentiary value, or did he have anything on him that was of evidentiary value?
No.
Let's talk briefly then about the vehicle, the reason for the traffic stop.
Mhm.
I apologize, I don't remember. Did you tell the court the reason for the traffic stop?
An expired registration tab.
Okay. Upon talking to the driver and looking into this deeply, were you able to confirm that the registration was in fact expired?
Yes.
Because the registration on the vehicle was expired, what did you do with the vehicle?
I pulled it over.
Can you tell the court more about that? Why did you have to pull it over?
It can't be driven on the roadway with an expired registration tab. It's against statute.
Okay, so it was in the road at the time, so you had to move the vehicle to, where did you move the vehicle to?
I parked it. I parked the vehicle in the parking spot.
Okay, thank you, sir. Before getting in the vehicle, did you do any kind of search?
Yeah, while staying outside of the vehicle, I looked into the vehicle and then I observed a black handgun magazine on the passenger side floorboard and also the handle with black handgun.
Okay, so to be clear, you saw this from the outside of the vehicle?
Yes.
How were you positioned in the vehicle, outside the vehicle when you saw the handgun?
Outside of the passenger side door.
I'm sorry, I gotta stop you. You say you saw a black handgun magazine where?
On the passenger side floorboard, it would be between the passenger seat and the center console on the floorboard.
I'm trying to understand, maybe I missed it. I understood that you took the passenger into custody.
Yes.
Why are you driving the vehicle? Where's the driver?
The driver was already pulled out of the vehicle.
I maybe missed why the driver was pulled out of the vehicle.
Okay, why was the driver pulled out of the vehicle?
The driver, while speaking to him, his hands were shaking. I took that as he was visibly nervous, and I wanted him out of the vehicle at that point due to him being visibly nervous. I wanted to get him separated from the vehicle. So
Okay.
At that point, I called for another officer. More officers arrived on scene, and then I escorted the driver out of the vehicle.
What's the reason that being nervous? What's the reason for what's the reason the driver appearing nervous made you want to take him out of the vehicle? Can you tell the court about that?
Based on my training, people being nervous on traffic stops can be normal, but if someone's visibly shaking, it leads me to believe there's something in the car that they don't want me to know about or they're nervous about.
So are you separating? So what's the reason for separating the driver from the vehicle?
Safety, I can ask him more questions outside of the vehicle.
Okay, and did you do that in this case?
Yes.
Okay. Was the driver placed under arrest?
No.
Was he cited for anything?
Expired registration tab.
Now, for point of clarification, can you explain to the court at what point during this traffic stop you actually did your search? As you
it was after I took a passenger into custody.
Okay. So the passenger got out of the vehicle, you placed him you notified him about the warrants, placed him in handcuffs. What did you do with him then?
Placed him in the backseat of my patrol vehicle after searching.
And then after you placed him in the back of your patrol vehicle, what did you do next?
Looked inside the vehicle using my flashlight without going inside it.
Okay, so it was at that point you went back to the vehicle to look?
Yes.
Okay.
I have a question. I'm still let the driver be removed from the vehicle. Did you ask the driver to move the vehicle before you got into, before you physically moved the vehicle to another location?
So I asked the driver if I could move the vehicle. I do not recall if it did have insurance or it didn't, but I asked the driver, hey, can I move the vehicle to a parking spot? And this was completely after the gun was found. And the driver was outside the vehicle, inside the backseat of another vehicle.
But you had already told the driver, let me take this step by step. You
Yeah.
stopped the vehicle. You noticed that the driver appears visibly nervous. You remove the driver from the vehicle. And then you don't, at that time, remove the passenger?
No, not at that time. I did not.
Okay, and then later, do you get IDs or something at this, is that what's going on?
Both driver and passenger were in the vehicle when I got their IDs.
Okay, and so, did you know that the passenger had a warrant before you removed the driver?
No, I did not.
Okay, so you hadn't run anything after, okay, so you got their IDs, but you noticed that the driver is nervous, you pull him out the vehicle, then you go in and run their information?
Yes.
Okay, and then you see that the passenger has a warrant?
Mhm.
Yes, a yes,
Yes.
and then you remove him, take him into custody? Okay, the car's in the middle of the road at the time, or
It's-
on the side of the road?
It's, I don't know how to describe it. It's in a parking lot for the apartment complex on 600 South Sycamore Street. So it's
Okay.
not at a parking spot. It's blocking the
Got
way
it,
for other
okay.
cars.
Okay, but when you remove the passenger, did you see a fire or the clip then?
No, I did not see it then.
Okay, you can continue.
Thank you, Your Honor. I apologize. I could have handled that timeline a lot better. Okay, so now the defendant is in the backseat of your squad car and you go back to the vehicle to walk around.
Yeah.
Can you tell the court the reason why you did that?
Another officer, he was on scene, looking inside the vehicle, and he told me something along the lines of, hey, you should come look inside the vehicle.
Okay, so based on that advice, what did you do?
I came and looked inside the vehicle and observed the magazine and the handgun.
Now, when you observed it, did you have to move anything inside the vehicle?
No.
When you observed the gun, did you have to open anything to observe it?
No, the passenger side door was already open. I did not move or do anything to see the handgun.
When you observed the handgun, did you take any photos?
I did.
I'm showing you what's been marked as People's Proposed Exhibit 1, Your Honor, may I approve?
Yes.
Do you recognize that photo?
Yes.
Is that photo taken by you? Oh,
Yes, the photos were
I
taken.
just
by
wanted to
me.
make sure he saw it.
thank you, Your Honor, I should have. And is that a fair and accurate representation of what you observed on October 1st?
Yeah.
I am now showing you what has been marked as People's Proposed Exhibit 2. Do you recognize that photo?
Yes,
What is that photo of?
of a black handgun and a black handgun magazine.
And did you take that photo?
Yes,
And is that a fair and accurate representation of what you saw on October 1st?
yes,
Your Honor, the people move to have People's Proposed Exhibits 1 and 2 admitted for the record.
1 and 2, any objections?
No objection.
Those 1 and 2 are admitted.
Published for the court, Your Honor.
Yes, thank you.
Thank you. Your Honor. So when you observed that you said you saw the magazine first,
yes.
how was it positioned on the floorboard when you saw it?
The magazine.
Yes, sir.
So the magazine was on the floorboard. If you were sitting in the seat to the left of where you'd be sitting, still on the floorboard, but between the seats and the center console.
Was it concealed in there or was it sticking out in any way?
The magazine was sticking out.
Okay. And it's sticking out in a way that you were able to see it from standing outside the vehicle, is that correct?
Yes,
What about the pistol grip of the pistol?
yes, I can see it from standing outside the vehicle.
So under the way it was positioned under the vehicle, the way it was positioned under the passenger seat. how would you describe where under the passenger seat it was located?
On the right side, underneath the passenger seat, the handle was facing the passenger side door.
And is it closer to the dashboard or is it closer to the back seat?
It's closer to the dashboard.
And from where you were standing, did it look like it was sticking out past the front seat?
Yeah, yes, it was visible.
Okay. So, and this was visible to you from how you were able to observe it from outside the vehicle, is that correct?
Yes,
Did you ask the driver about the pistol?
yes.
What did the driver tell you?
He said he didn't know there was a gun inside the vehicle.
Did you ask the defendant about the pistol?
Yes,
And what did the defendant tell you?
he said he didn't know there was a handgun inside the vehicle.
During this whole interaction, how would you describe the defendant's demeanor?
I mean, upset. I know he called his son during this.
Was he cooperative?
Yes.
I don't have any further questions.
Cross-examination.
Thank you, Your Honor. Thank you, Officer. So just to reiterate, one of the things that made you want to continue on with the investigation, or the primary thing, was that the driver was acting nervous.
Yes.
Gotcha. Did you observe the weapon that you later found in anybody's possession at any time?
What do you mean by possession?
Did you observe anybody holding the weapon?
I did not observe anyone holding the weapon.
Did you observe anybody stash or store the weapon under the seat?
I did not observe that.
Okay. Based on the position of the gun, you made an assumption that perhaps the passenger had stored it under the seat.
Yes.
Okay, but you couldn't say if perhaps somebody at some earlier time had opened the passenger door and stuck the gun under the seat or got there any other kind of way.
I can say from the time I saw the vehicle, no one else got into the vehicle by the time I stopped it.
Right, but the gun was already placed where it was placed when you got involved, right?
I can't say that if it was placed there by the time I got involved.
But you can say you don't know when it was placed there.
Correct.
Okay. And Mr. Taylor said he didn't know there was a gun in the car.
He did say that.
Right. And he said he didn't own that gun, correct?
Correct.
Did Mr. Taylor tell you how long he was actually in the car before you pulled it over?
Mr. Taylor, who's Mr. Taylor?
I'm sorry. Mr. Layton, I don't know why I have Taylor. Well, did Mr. Layton tell you why, or how long he was in the car before you pulled the car over?
I believe you said approximately 5 minutes.
Approximately 5 minutes. Okay. Who was the registered owner of the vehicle?
The driver.
Okay, and that's Mr. Antoine Lilly, correct?
Correct.
Okay. And did you investigate to find out who owned the gun, who was the gun's owner?
Yes.
And who was that?
Devion Lilly, I believe that's how you pronounce his first name.
Devion Lilly. And are Devion Lilly and Antoine Lilly related to each other?
Cousins.
They're cousins.
Let me stop. I'm confused. So the defendant was the passenger?
Correct.
Okay, and the firearm was registered? So what you're saying?
The firearm was registered to Devion Lilly.
Devion Lilly, okay, thank you. You
And
can
again,
continue.
Devion Lilly is the cousin of the driver, Antoine Lilly, correct?
Correct.
And did you ask Antoine Lilly if he had seen Devion Lilly recently?
Yes.
And what did he say?
I don't recall the exact timeline that is contained in my report, but I believe, I don't want to make an assumption based on the
If I
timeline.
said 4 days prior, does that sound about right to you?
Possibly, yes.
Okay, would it help you if I refresh your memory? with the
Yes.
report? Is that okay with you, sir?
Yes, yeah.
So the second paragraph, right there.
Are we refreshing his recollection? as we move?
Refreshing. So just again to be clear, Antoine Lilly was the driver, Devion Lilly was the registered owner of the gun. And you asked Mr. Antoine Lilly if he had seen Devion recently, and what did he say?
He saw him 4 days ago.
So 4 days prior, he had been with Mr. Devion Lilly. Did you find anything else illegal in the car?
No.
Did Mr. Lilly say that anybody else had driven the car recently?
Yes, he said another person has driven.
Did you make contact with the gun owner?
I did have another officer on scene.
Okay, and do you know what the result of that contact was? In other words, did Mr. Devion Lilly say that he knew the gun was in the car?
I'm gonna object this to hearsay.
Yeah, I'm going now based on the police report. Ownership of property is not hearsay under the court rules.
But whether or not I believe the question was with respect to whether or not Davion Lilly would know the pistol was in the car. So I would object to the form of the question.
How was it formulated? Your question was did you know if any other officer made contact with the supposed owner of the firearm and if he made any statements about
Yes.
firearm?
Yes.
So I believe the question was whether or not he knew the gun was in the car. I think there's another way to ask the question.
Yeah, I agree. You can rephrase it.
Okay. So did the other officers make contact with Mr. Devion Lilly?
Yes, Officer Zachary.
Okay.
You said Officer Backman did?
Yes.
And to the best of your knowledge, did Mr. Lilly claim ownership of the handgun?
Yes.
Okay.
Well, Devion really did.
Devion Lilly, yes. And did Devion Lilly say where he thought the gun was at?
You'd have to refer to Officer Zachary's report.
So just to summarize, Antoine Lilly was driving a car that he is the registered owner of, correct?
Correct.
And he was acting nervous, was prompted further investigation.
Correct.
And that investigation resulted in the discovery of a weapon registered to Mr. Lilly's cousin, correct? Devion Lilly, Antoine Lilly's cousin?
Yes.
Okay. And Antoine Lilly admitted to seeing Devion 4 days prior.
Yes.
The gun was never seen in Zachary Leon's possession.
You'd have to define possession.
Holding the gun,
I did not see him hold the gun.
and you did not observe him hiding or stashing the gun.
I did not observe him doing that, no.
Okay. And he did deny, that is Zachary Leon denied knowledge that the gun was in the car.
He did.
And he also said that he'd only been in the car for about 5 minutes.
Yeah.
Okay.
No redirect, John.
Okay. I think Mr. Lee's last question kind of clarified my other question, which was there any observation of any like furtive movements of maybe he was trying to hide the defendant was trying to hide a gun? Any objects?
I did not observe any. No.
Okay. Was the firearm tested for any prints or anything?
I do believe an officer did test it for DNA.
Well, it was not you.
No, it was not.
Okay, okay. And then you didn't make contact with the owner, it was a Debian. I mean, Officer Baffy made contact with him, so my question would actually be for Officer Baffy. Okay, let's see. The other question I have is, I just need a better explanation of what exhibit 1 is supposed to show me. And maybe you can help them identify what evidentiary value this is for me, because I don't see
Yes,
what
sir.
I'm supposed to be seeing.
I actually meant to do this on direct. Could you circle where you see the pistol and the magazine?
Yes. You want me to point it out where I see them? There's 2 different circles.
I think with the circles.
Circle.
Is that fine?
I got you.
Thank you.
Thank you. Okay, and just for my clarification, is this supposed to be like is exhibit 2 is a zoomed in version?
Yes.
Okay, because I could see in 2, oh, maybe it doesn't show both portions. What portion of this picture is this that section?
No, the handgun would be the left circle. Top.
But isn't this okay, this is the bag, correct?
That's the magazine.
I'm looking at this pink right here.
Yeah.
This is pink right here.
Oh, yes, that's the bag.
So you're telling me that this is on that side? But there's paper right here and there's paper there.
I guess I'm not understanding your question.
I'm trying to find out what portion of the zoom in, this appears to me to be zoomed in to what is on the right side of this picture. Is that accurate?
What's on the right side of it?
This is the right side of this picture,
Yes.
here where you circled, the circle on the right?
Yes.
This is supposed to be a zoom in of that?
I believe the picture captures both the handgun and the magazine. I think that's what I was trying.
This one?
Yes.
I don't see both. This only appears to show me.
Oh, here, I can point out the magazine on the second. photo
Okay,
if you'd like.
please. Is it supposed to be cut off? Is that what's going on?
Yes, that's the magazine.
Okay, got it. So it's cut off. So the magazine was located, so then you
Okay,
really
yeah,
can't see the
okay, so
magazine
that
in
would-
there.
from that
The
photo, yes,
circle is
that's-
not
that's my fault,
accurate.
yes.
Okay,
Okay.
that's where I'm confused.
Yes, that's my
So
fault.
the this one cuts off the
Yes.
magazine because the paper.
Yes.
Okay,
So,
so
yes,
got
that's-
it.
That second circle does not circle. the
Makes
magazine.
sense now. Okay,
Yes.
thank you.
I apologize. Your Honor.
That's not, no, that nothing to do with you. I just need him
Yeah,
to
that's
clarify
my
what I'm
fault.
looking at here so I know what's happening
Yeah.
here. Okay. May this witness be excused.
Yes, Your Honor.
And actually, one more question, just because I have to clarify this. You said on your direct that you pulled the driver out because based on your training, if they're visibly nervous, the driver may be concealing something in the vehicle.
Yes.
Did they train you that it could be that they're nervous that they're having an interaction with the officer?
Yes. That's
Okay.
possible.
Okay, so would that warrant you pulling someone off the vehicle
So,
if they're nervous?
I've had multiple traffic stops where people are nervous. He was the only one where someone was visibly shaking his hands. Other people act nervous in different ways, but I've never seen it to that degree.
Okay, so because his hands were shaking, you thought that warranted that he was probably concealing something and not nervous about the interaction?
It was a possibility.
Okay, no other questions. Thank you.
Yes. You can use this.
You can call your next witness.
No further witnesses, Your Honor. People are-
Any defense witnesses? You can make arguments.
Thank you, Your Honor. So the people would be asking that this be bound over on counts 1 through 3. The circumstances of the stop. Well, with respect to this defendant, the defendant was taken into custody for for a warrant, which that'd be the reason why the defendant here in this case was removed from the vehicle. The officer's testimony shows that through a plain view search, I shouldn't say, it's not even a search, well, through a plain view observation of the vehicle, the officer saw the pistol grip of the pistol sticking out from underneath the passenger seat where the defendant was seated. And in addition to that, there was a magazine that the officer could see from standing outside of the vehicle. Based on the observation of the locations of these items, there's a couple of different theories that could be possible here, but I think getting to the bottom of it would be a question best left to a jury. Looking at the jury instructions, first that a pistol was in the vehicle the defendant was in. The testimony and the photos submitted during the exam show that there was in fact a pistol present in the vehicle. Second, that the defendant knew the pistol was there. We have, in this case, circumstantially, there's a reasonable inference that can be made that the defendant knew the pistol was there because of how the pistol was located on the floorboard underneath the passenger seat, and because it could be seen from standing outside of the vehicle. It looks like either the defendant knew the pistol was in the vehicle when he was in there, or that the defendant could have placed the pistol there. It's also possible, although there would need to be more testimony. Maybe the driver gave the defendant the pistol since it was registered to his cousin, and then the defendant took part in concealing the pistol underneath the passenger seat. There are several theories that
There's a lot of possibilities.
Many possibilities.
Many possibilities.
So but as I said, merely circumstantially, given the position of the pistol, it looks like the defendant should have known or knew that the pistol was in the vehicle. And then third, that the defendant took part in keeping the pistol in the vehicle. Again, that element is probably best left for a jury, possibly because of the position of the pistol in the magazine. If the defendant placed it there, then he took part in keeping the pistol in the vehicle. If the driver handed him the pistol, then he took part in concealing the pistol there and had a part in concealing it in the vehicle. If he sat in the seat having the pistol already there, by not disclosing it to the police when the police were asking, when the police approached, he took part in trying to conceal the presence of the pistol. Based on the testimony and the photographic evidence, the people are arguing that there is a reasonable inference based on circumstantial evidence that the defendant probably knew the pistol was there and took part in keeping the pistol in the vehicle. And it's for that reason that we are asking that count one be bound over. With respect to count two, we stipulated to the prior conviction. Count two, with the presence of the pistol and where it was, I think. Looking at the statute for possession by a prohibited person, first, the defendant knowingly possessed a firearm in this state. Second, that at the time the defendant had previously been convicted of a felony. Third, that less than 5 years had passed. And fourth, that the defendant's right to possess had not been restored. So in this case, the presence of the pistol would be constructive possession for the purposes of count two, and then count three, the felony firearm, would be attached to count two, Your Honor. And so based on the testimony and the photographic evidence, people would ask that counts 1 through 3 be bound over as charged.
Thank you, Mr. Lee.
Thank you, Your Honor. As the prosecutor has stated, the key elements that are in question today are: did the defendant know the gun was there, and did he have possession and or control of the gun? The prosecution has made a leap and determining that because the officer outside the vehicle, looking at a lot of different angles with a flashlight, could see something that he believed was a gun, that a passenger who just jumped in the car would have obviously seen it. I think that's a big leap. Again, the only reason why the investigation was continued was because the driver, Antoine Lilly, was acting nervous. Again, there's multiple reasons why that may be true, but there was no nervousness displayed by Mr. Layton. He was not removed from the car because they suspected he was hiding something. He was removed from the car because he had an outstanding warrant. The gun was never observed in Mr. Layton's possession, that is in his control. He was never observed stashing or hiding the gun. He denied any knowledge of it. He denied any ownership of it. And in fact, it was determined through the investigation that the ownership of the gun was Devion Lilly's, the driver's cousin. So if you're looking at it from a circumstantial standpoint, which is what the prosecutor is doing, circumstantial evidence all tends to point to the driver of the vehicle, not the passenger of the vehicle. The only thing that suggests the passenger of the vehicle had anything to do with it was what they considered the placement of the gun. And again, they cannot say how the gun was placed there or by whom. Therefore, Your Honor, we do not think that the prosecution has met its burden. We believe that they cannot prove knowledge, ownership, or possession. And if that's true, then they cannot prove the carrying a concealed weapon charge, or the felony firearm or the felon in possession charge, Your Honor. We would ask that these charges be dismissed and not be bound over.
Thank you. Okay, today's is the date that was scheduled for preliminary examination. The burden is really upon the prosecution to establish if there is sufficient probable cause that the felonies was committed, and sufficient probable cause to charge the defendant with the felony. It's not a trial. They don't have to prove each element beyond a reasonable doubt. They just need more than mere suspicion that the crime were committed. The court is the sole determiner of credibility of any witnesses. This is a common sense standard that's going to be used here based on the circumstances presented today at today's hearing. And the court is also in the position to weigh the likelihood of the government's success or their ability to establish guilt at trial, and whether or not the evidence raises any reasonable doubt about the defendant's guilt. I had testimony today from Officer Carter Hurld, I believe is how his name is pronounced. He has been an officer with the Lansing Police Department since May 6th, 2024. So just about 3 months prior to the alleged incident. He testified that on or about the date of October 1st, 2024, that he effectuated a traffic stop for an expired registration tab, that he made contact with the driver of the vehicle, someone by the name of Antoine Lilly, and that the driver appeared nervous, that his hands were shaking or visibly shaken, and that there was a passenger in the vehicle. That passenger later identified as the defendant in the court today, Zachary Leon. The officer indicated that he received identifying information from both parties, but due to the nature of the serious nature, I should say, or distinctive nature of the nervousness of the driver, he removed the driver from the vehicle for safety reasons, because in his short term of serving and patrol, he believed that to be a little abnormal, the amount of nervousness. And so for safety, he removed him. After running information, he determined that Mr. Layton did have a warrant, warrant of some sort. And so he would be taken into custody on that, and that he searched the defendant. He didn't find anything of evidentiary value, and that he, after taking the defendant in custody, went back to the vehicle, which is now empty and not in an actual parking space but needs to be left in the parking space because it's not properly registered. At which point he testified that he used a flashlight to look into the vehicle on the passenger side. People's Exhibit 1 is demonstrative of what would or could be seen in plain view if no one is seated in the chair. This is an empty chair, and a flashlight is shown, and he was kind, the officer Earl was kind enough to circle the spots or portions that were later identified to be a magazine and the handgun handle. People's Exhibit 2 show a handgun, and then it does kind of cut off what I believe is supposed to be the magazine, but it's a black piece or item on the ground. Looks like there's a plastic bag, there's a roll up paper, there's maybe a charging cord or something. There's something else black in front. I'm not sure, but I'm saying all this to demonstrate that this doesn't seem like it's the tidiest car. And so officers, based on the observation of the gun, questioned the passenger about his knowledge or ownership, possession of that firearm, to which the passenger states he was not aware there was a firearm there. The officer questioned the driver, who also said he didn't know that there was a firearm there. And then the placement of where the firearm and the magazine was located is what caused the officer to take the passenger, or to charge, I say, the passenger with possession of or carrying a pistol in a vehicle. Let's see, the jury instructions required for the people to be able to prove at trial, first, that there was a pistol in the vehicle that the defendant was in. That, I think, is unequivocal. Second, that the defendant knew that a pistol was there. We have a question there. Third, the defendant took part in carrying or keeping the pistol in the vehicle. Yet and still there, we have another question. The concerns and questions that the court has at this stage is that, just imagine you get picked up in the middle of the night and it's dark. It's clearly dark. Speak out on my record one more time. I don't think it's gonna be fair for you. I know it's hard to control yourself, but you gotta. Imagine it's dark and you get picked up to get a ride somewhere. We're gonna use Mr. Cornish as an example. Mr. Cornish needs a ride because it's dark outside, and so Mr. Lee picks him up. Do you think he's looking under the seat and investigating in the dark with his flashlight to see what's going on down there? Or do you think that he's just getting a ride? Imagine how scary it is for any of us that we could end up in someone's car and we don't know what's under the seat of their car. And we can now be accused and charged and maybe even possibly convicted of being responsible for what was under their car. This happens often. It happens often, and a lot of times it's because that passenger actually put that there. But what are glaring red flags for me that I think that the prosecution, and I'm not blaming this on you because you don't choose your cases, and I think that you walked in here knowing that this probably was a weaker case. The issue is that the gun is registered to someone who's related to the driver of the vehicle. I'd still sit here, I don't even know who's the registered owner of this vehicle. That's a whole nother issue. But the driver and the person who he had to remove from the vehicle because he's so nervous have the same last name, and admit that I just saw him 4 days ago. He never entered the vehicle. Yeah, but you all are related. I have no information that this person even knows the owner of the firearm. No relation, no information about ownership, just that he got into a vehicle in the dark and he's now supposed to be responsible for a firearm that's found under the seat because he should have known it was there. Why should he have known it was dark? On top of that, there was no evidence of any furtive movements. You didn't even see any. I know he learned that in training and experience. Did you see him move or, any gestures? He gave no concern about how the passenger exhibited himself during the interaction. It was the driver that was nervous. I think there's more probable cause that the driver, who had the same last name as the registered owner, knew that there was a firearm in the vehicle and took part in keeping it there. I don't think there's enough probable cause or that there's enough evidence that could support a finding of guilt at trial to charge and convict this person, Mr. Layton, with having knowledge that there was a pistol in the vehicle based on these circumstances, or that he even took part in carrying or keeping the pistol. Even if I were to surmise that Mr. Lilly gave the firearm to this defendant, which we don't have that in facts, that there's nothing to support that right now, just a complete bogus hypothetical. Even if I were to believe that that's a possibility, that doesn't necessarily mean that he took part in keeping it in the vehicle. You pick me up, I get in the car, and then when the police is coming, you hand me something and tell me to put it under the seat. Now I'm responsible for keeping it in the vehicle? What am I supposed to do, throw it out the window? So no, for those reasons, there's lack of probable cause, the case is dismissed.
Just to be clear, it's gonna be on all three counts, Your Honor?
I think you need the first count to get the other ones.
Well,
Firearm possession, felony firearm. You need the first one. If there's no possession by this person, he can't get a felony firearm
I'm
or
just saying,
felon in possession.
I'm just saying for the record, I think a constructive possession could still support, but I'm not saying that the court is wrong in dismissing count two. I was just checking to make sure that all three counts. were dismissed.
Constructive possession as to count two.
Yes,
Well, I don't, the issue is I just put on the record that I didn't believe that he had any knowledge at all, so he couldn't have a constructive
fair enough,
possession.
yes. I just,
So counts 1, 2, and 3
thank you.
are dismissed for lack of probable cause.
Thank you very much, Your Honor. That's what I was saying.
No problem. I'll give these back
Thank you.
and you can type for dismissal. No, I think it's supposed to be that, but I could be wrong. I think it is.
This is not.
Okay, let's see. Okay.